Welcome, everyone. We're pleased that you've joined us for today's webinar titled What Every Financial Professional Needs to Know About Elder Financial Abuse. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter will be Jennifer Lawler. Jennifer is a senior consultant with Advanced Underwriting Consultants. Jennifer has a background in tax and in law and in working with closely held business owners. And now, here's Jennifer.
Thanks, Linus, and thanks for joining us today. Today we'll be talking about elder care abuse. According to a recent U.S. Census Bureau report, baby boomers, those born between 1946 and 1964, represent approximately 75 million people living in the U.S. Because these boomers make up such a large demographic, they are changing the way that we think about and conduct business. Laws are also changing in order to protect this large demographic. As the number of older Americans grows, the areas of law and regulations concerning this demographic will continue to grow as well. Every state in the United States, including the District of Columbia and most of the U.S. territories, has at least some laws in place to protect its older residents from financial exploitation and abuse. These laws and their scope vary by state, but the goal is the same: to protect its aging population from those that would take advantage of them. In addition to statutory laws, courts have also attempted to punish financial professionals who may have taken advantage of older clients, and we'll discuss some of those cases a little later on. In order to better serve clients, as well as ensuring that the pertinent laws are being adhered to, those in the financial planning business should be aware of the relevant laws and rules for their state. State laws vary greatly. They vary according to who they protect and how much protection they give. For instance, some states define an elderly person as one that has attained age 60, while the majority of states define an elderly person as one who is age 65 or older. Some state laws include those with diminished mental capacity because of physical or mental disability. Several states have both criminal and civil statutes, meaning that a person who takes advantage of a protected person can receive jail time if found guilty of financial elder abuse, as well as be sued for civil damages. To illustrate some of the differences, let's look at two states' statutes. Some states, such as California, have lengthy statutes that have special sections for each area. This statute specifically deals with financial abuse of elders. It defines what financial abuse is and the actions a person might take to lead to a conviction of financial abuse. It tells us that an individual commits financial abuse when they take, secrete, appropriate, obtain, or retain real or personal property of an elderly person or dependent for wrongful use or with the intent to defraud. A person also commits financial abuse if they assist someone who does these things. Likewise, if an individual accomplishes these things by undue influence, they have committed financial abuse. California's statute goes further than most in that a person can be found guilty of financial abuse if they deprive an elder of the use of their property, or if they coerce an elder into leaving property to a certain person or entity through a will or trust. The statute also defines a representative as a conservator, trustee, or other representative of the estate of an elder or dependent person, or an attorney in fact of an elder or dependent person who acts within the authority of their power of attorney. So in California, having a power of attorney or some other financial appointment does not protect one from these types of charges. Some states have much shorter and condensed laws. Vermont, for instance, combines its financial exploitation laws with its sexual exploitation laws in one statute. It defines exploitation as willfully using, withholding, transferring, or disposing of funds or property of a vulnerable person without legal authority, and acquiring, possession, or control of property by using undue influence, harassment, duress, or fraud. It also includes forcing a protected person to do something they don't want to do or taking sexual advantage of a protected person. You can see that these two statutes vary greatly. California's is very detailed, and that one statute took up 2 slides, whereas Vermont's statute is very kind of vague and is much shorter and condensed. Luckily, we don't have to memorize all of these statutes. The United States Department of Justice has created a website database that allows the user to search all of the elder abuse laws by state. You can search for both criminal and civil statutes. I have provided the link for the database as well. It's the first link on this slide. Some states also have laws that require mandatory reporting when a person suspects that an elderly person is being taken advantage of. States vary in who they name as mandatory reporters. Doctors and physicians are almost always listed if they suspect physical abuse, but in some cases, bankers and financial professionals are also named as mandatory reporters. If they fail to report, they can be prosecuted for that failure. A list of states' mandatory reporters can be found at the second website listed on this slide. As I mentioned earlier, this area of law is growing, and as a result, we are seeing more and more court cases related to elder financial abuse, and are likely to see more as states refine their laws. Some of these cases reinforce the need for laws of this sort. Others are examples of how well-intended actions can backfire. And some of these cases are outright bizarre, demonstrating how states can and do sometimes overreach. This first case, Mahan v. Charles W. Chan Insurance Agency, is an example of a case where these types of laws are needed. The Mahans were an elderly couple in their early 80s. They had had an ILET with 2 survivorship policies that had been enforced since the mid-90s. The trust itself was self-sustaining and did not require any additional funds to pay the premiums on the existing policies. Mr. Mahan was starting to suffer from cognitive issues, and Miss Mahan was diagnosed with Alzheimer's disease. The Mahans believe that the Chan Agency knew of and took advantage of Mr. Mahan's diminished state. When Mr. Mahan went to visit the Chan Agency to purchase casualty and earthquake insurance. The Chan Agency offered to review Mr. Mahan's existing policies and assured him that they could purchase more insurance without any additional cost to Mr. Mahan. Mr. Mahan agreed. The agents at the Chan Agency deceived the Mahans' trustee, and the insurance carriers involved through a series of lies, deceptions, and misrepresentations. Because of the Mahans' advanced age and diagnosis, they did not qualify for underwriting easily. Mr. Mahan not at all. The Chan Agency did eventually find a carrier that would issue a term policy on Mr. Mahan's life. The term would expire once Mr. Mahan reached age 91. The premiums for the new policy were drastically higher than those of the existing policies. In order to pay the premiums, the Chan agents surrendered one policy and heavily loaned out the other. The new premiums cost exceeded the old premiums cost by more than $100,000 annually. By the time the dust settled, neither of the Mahans were insurable. The trust was completely drained of funds, and in order to pay the new premiums, the Mahans would have to spend an additional $1 million over the life of the term policy. The Mahans had significant tax bills because of the surrender of the first policy, and were likely to get hit with another tax bill when the heavily loaned out policy collapsed. The Mahans sued the Chan Agency under California's elder abuse laws. The trial court sided with the Chan agency, finding that the trust was the entity that suffered harm and that the elder abuse laws did not apply to the trust. The finding was overturned by the appeals court. The case has yet to be settled, but if the Mahans' allegations prove to be true, this case is clearly an example of an agent taking advantage of an elderly person's decreased mental capacity. The Dunn v. Patterson case shows how good intentions can sometimes backfire. The Dunns visited an attorney, Mr. Patterson, for estate planning documents. When Mr. Patterson drew up the requested documents, they included a paragraph that said that in order to make changes to the documents, Mr. Patterson would have to meet with the Dunns and then approve said changes. Otherwise, the Dunns could petition the court to change the documents. Mr. Patterson made certain that the Dunns were aware of the paragraph, and the Dunns signed off on all of the documents. Several months later, Patterson received a letter from another attorney stating that the Dunns had come to him to change their documents because they did not want changes to be contingent on Mr. Patterson's approval. The Dunns brought suit for declaratory judgment against Patterson, claiming that it was against public policy and that the Dunns had an absolute right to alter or amend their estate planning documents whenever they wanted. Dunn argued that he included the paragraph regularly in order to protect clients from undue influence, and that he had doubts about Miss Dunn's capacity. Mr. Patterson argued that all the Dunns needed to do was meet with him to establish their capacity and lack of undue influence, but the Dunns refused. The trial court found for the Dunns. The appeals court, however, overturned because it was legal under Illinois' law to require a third party's approval for changes to legal documents, and the Dunns were aware of the paragraph before they signed off on the documents. The court noted that while Mr. Patterson had good intentions, he put himself into a very difficult situation. If the Dunns had been unduly influenced and Patterson had approved the changes, Patterson would have been subject to suit. However, Patterson had taken measures to make sure that the Dunns were competent, and he still got sued. Gertzon versus Great American Life. In 2011, 80-year-old Joyce Gertzon purchased a fixed indexed annuity from Great American Life. The annuity included surrender charges if withdrawals were taken within the first 10 years that exceeded 10% of the contract. The disclosure found on the policy did not contain a reference to surrender charges, but did mention early withdrawal charges. In 2015, Joyce took a withdrawal from her annuity that resulted in surrender charges. She brought suit under California's elder abuse laws and California's unfair competition law, which required that when an annuity includes surrender charges, the information be included on the cover page and include a notice disclosing the location of the charge, the time period, and any associated penalty. At trial, Joyce testified that she couldn't recall if she had read the whole disclosure. Great American argued that Joyce did not read the notice, and so it wouldn't have mattered if the information had been included. The trial court denied Great American's argument and found that there were sufficient facts to move the case to trial. This one is still working its way through the system, but the lesson in it is to make sure that all needed disclosures are included. And finally, the bizarre. People versus Neesham. February 2008, Fran Schuber, then 83 years old, and her boyfriend visited Glenn Neesham's office so that Miss Schuber could purchase an annuity. Schuber's boyfriend had already purchased a similar annuity and thought it would be a good fit for Miss Schuber. Miss Schuber visited her bank to withdraw $175,000 in order to deposit it into the new annuity. A bank employee thought that Miss Schuber's boyfriend was unduly influencing her and contacted the California Department of Social Services about her concerns. Schuber purchased the annuity and named her boyfriend as the beneficiary of the annuity. Investigators interviewed Schuber and concluded that she was likely suffering from dementia. After that finding, Neesham was indicted for criminal theft and embezzlement. Neesham's employees testified that they believed Schuber understood what she was buying and that the purchase was her own competent choice, and there were multiple employees that testified to this. The jury was given bad instructions and was not instructed that in order to be found guilty, Neesham must have intended to steal from Miss Schuber. The jury found Neesham guilty. Apparently, the jury felt like it was not in Miss Schuber's best interest to purchase an annuity at her age. The case was eventually overturned in the Court of Appeals, but despite that, the prosecutor in question continued to pursue the case, even petitioning to the California Supreme Court. The court declined to hear the case, and Neesham's license was eventually restored. This case is truly bizarre because there was never a formal complaint lodged against Neesham from Schuber or from anyone in her family. The case came to fruition because a manager at a bank was afraid that an elderly woman's boyfriend was taking advantage of her. Neesham was then entangled in a long, drawn-out case that cost him his license for several years and forever damaged his reputation. This area of law is ever growing and changing, but from these cases we can learn a few things. Namely, having good intentions when dealing with older clients is not enough to keep everyone safe and satisfied. Some practical tips that might be useful when dealing with older clients are to carefully document the reason a particular financial product is being sold. Create procedures to determine a client's mental capacity to engage in financial transactions. Involve family members and the client's other financial advisors in transactions involving older clients to the extent possible. Treat every allegation of a client's mental incompetence as a sign to tread carefully. And finally, if you see that a client or prospect is being taken advantage of, consider whether or not there is a duty imposed by law to report suspected abuse. Thanks for listening in today.
Thanks, Jennifer. I'd like to thank each of you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. That's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Feel welcome to join us for the next webinar on the first Wednesday of next month, September 6th, at this same time. Next month's webinar will be titled Choosing Between Bonus, Split Dollar, and Deferred Compensation. You can also find an archive of past webinars on our YouTube channel. Today's presentation will be posted on our YouTube channel by the end of this week. Finally, for more information about the services that Advanced Underwriting Consultants offers, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again, and best wishes for continued success.